everyone. As you all know, we are in the much anticipated session of criminal law by Kunal, our very own MBL classmate. So he has prepared quite a bit of material, and I hope all of you have opened the CrPC Act, which Vipul has shared some time ago in the group. If not, you are requested to keep it open for your ready reference and keep it with you. So he'll be using his PPT. Probably he'll be switching in between the act also. So please keep the act open in your mobile or in your device, whichever you're logging in from. So he has requested for that, and so I'm leaving the stage open for him so that he'll take over whenever he's ready. Please keep the act open. Once again, I'll request you.
Is my screen visible now?
Yes, very well.
Kunal is a true
Should I start?
presenter. He got ready with all his suit and everything.
Or Kunal,
I'm visible also, right?
No, you are visible, Kunal.
you went Kunal somewhere to attend some party or
He is
function.
visible. No,
No,
not
no,
the
no, no,
screen.
no, no. I just, yeah, yeah. Screen is also visible, right? I have my other device also where I'm able to see both. Yeah,
Yes,
yeah.
yes.
So I'm just starting off. So, good evening, everyone. I am Kunal Motwani. I'm a practicing advocate before the Bombay High Court and other courts in Mumbai. I've done my Bachelor's of Commerce undergraduate degree, LLB degree, 3 years course from KC Law College, and LLM specializing in criminal law from KC Law College just last year. I've been into the field for about 2.5 years, exclusively doing criminal for about 1.5 year or so. So today's presentation, the agenda is to just give you a brief overview of the criminal justice system. Today, I am focusing more on the procedural aspect. Therefore, we have shared the CrPC Bear Act. I am not touching much on IPC, though where relevant, I'll be pointing it out specifically. Otherwise, I am not going to expressly touch on IPC or Evidence Act. Just two disclaimers. This is as per the prevailing law, that is CrPC, and the other legislations which are on today's date, not the three codes which are proposed in the parliament, which are yet to form into a act as of now, because it is pending for scrutiny before the relevant committee, and then it will be passed, and then it will go to the president for signing. So till now, as on date, CrPC is the one which is still uh, you know on force, and I'm going to touch more on that. So please bear in mind that this presentation is more focused on CrPC rather than those three codes, and this presentation is basically as for educational purposes, to give a understanding and brief overview. This is only to educate everybody. Please don't एकदम hard and fast stick to it. I i am also no expert to in the field. I am also trying my best to learn on the job, and suppose if I make commit any error, then please point it out to me. I would be happy to take that criticism in a positive way. Before I actually step into the presentation, one sincere request: please do not interrupt by switching on the microphone or the video. Kindly allow me to make my submissions first. It may look like a one-way dialogue, but I'll give you all time in the end to ask any queries from the presentation or something relevant to the topic, which is in my domain. I will be able to help out. I'll surely do. Please put your queries in a typed format in the chat box if possible, because I may not be able to take it in the middle of the presentation. It breaks the flow of the presentation. If any specific addition inputs are there, then you may please raise your hand and speak only when called upon. Please don't cause chaos like it happens sometimes in the regular classes also. And most importantly, here it is an educational purpose session. That is what I said. I am not going to discuss any nitty-gritties of any specific case or give out any free legal advice to anybody. Any sub judice matters will not be entertained. So when we start off with the session, my idea is to bring you down to the basics first, to understand the difference between substantive law and procedural law. I understand that a lot of my friends here are not from non-law background. There was a specific course for legal studies which was taken. I hope this was covered, but I'll just brush upon it slightly. In simple words, the law which prescribes the rights and duties, describes the offenses and imposes punishment is a substantive law. Substantive law is more having more gravity because it is individual specific. It explains the rights, duties, obligations of the parties. It prescribes the offenses and imposes punishment. Whereas the law which prescribes procedural aspects for the implementation of such substantive law is a procedural law. So for enforcing these substantive law actually on ground in courts, you need to take support of procedural laws. Therefore, procedural laws are sometimes referred to as adjective laws, as they are for the purpose of enforcement of such substantive laws. For example, IPC, Companies Act, Contract Act, which we have studied, are substantive laws, whereas CrPC, CPC, Civil Procedure Code, Criminal Procedure Code, Evidence Act, all these are procedural laws because these contains the rules of how the substantive provisions are to be applied in courts actually. I hope that's clear. I'll address questions on this later. So when it comes to criminal law, there are three primary criminal legislations. One is CrPC. Of course, we are going to discuss this to a certain extent today. Then there is IPC, which is a code in itself, which has over 500 sections prescribing various types of offenses. This was an act of 1860, which was drafted by Lord Thomas Babington Macaulay, Lord Macaulay as we call him in short. This, as a code, has stood the test of time since 1860 till date for over 150 years. Then there is Evidence Act 1872, which was drafted by Sir James Stephen. This law helps us regarding the evidentiary aspects when it comes to a trial. Evidence Act, mind you, is not just for criminal because it gives a general understanding. It is also applied in cases in civil cases also. So Evidence Act, being a procedural law and general in nature, is generally applied in civil as well as criminal. But when it comes to criminal law, these are the three base laws. Therefore, I've put up a picture of a criminal manual. It is called as Criminal Major Acts, and sometimes in practice we called it as 3-in-1. If all can see my this is the book which I generally use. Of course, the cover has been washed up for because of regular use, but this is what the three acts predominantly which are used in the criminal side. Now, this slide focuses more on certain fundamental principles of criminal law. These are, though some may not be expressly written, but these are followed in India, especially in the criminal law system and also in certain other common law countries. The golden thread running through our criminal justice system is that an accused is innocent until proven guilty. So this is the presumption of innocence. So any person who's an accused, mind you, the word used here is accused, not a convict. Convict is separate, accused is separate. Accused is a person against whom an accusation is made. Convict is a person against whom conviction has been granted by the court upon holding a trial or upon his admission of guilt. Second, burden of proof. The burden of proof in criminal side is that the prosecution has to prove the case against these accused persons that they are guilty beyond reasonable doubt. Please understand the threshold here is very high because the word used is beyond reasonable doubt. There should be no scope left while the court is deciding the case that this person and this person alone on this date using this method, using this arms, ammunition or any other weapons in that case has committed this act which is an offense under this provision, and therefore he is held guilty. So the prosecution in this case has to go to such a higher level to prove that no other person other than this accused person has committed the crime. The court should be absolutely certain that no other person has done it but this person, this accused person. Mind you, this threshold is only in case of criminal law, whereas in civil law, it is preponderance of probability, that there is a likelihood or a probable chance, though it doesn't say beyond reasonable doubt. Here, in civil law, it is a lesser threshold compared to criminal law. Then next, coming to this is a very common saying a lot of people might have heard: let 100 guilty be acquitted, but one innocent should not be convicted. So when upon a trial is concluded, the court pronounces a judgment when deciding the guilt of the accused person. There are two options. One, when the prosecution has convinced the court that this accused has committed the crime beyond reasonable doubt, he gets convicted and is liable for punishment according to law. If the prosecution fails and the defense creates a probable version that the accused person may not have done the offense in the manner as alleged, then he may be acquitted. So acquittal is like, you Hindi mein people call it as ba izzat bari, ba izzat bari karna. So that is how it is acquitted. So the saying is that let hundreds of accused persons who are guilty be acquitted, be let off, be gone scot free, but not an innocent person should be convicted. This is a very important point so as to understand that the threshold when it comes to proving a criminal case by the prosecution is very high, and that criminal case is not like a civil case where the ultimate aim is to seek either compensation or injunction or taking over of any property in that sense. Here the ultimate outcome is that the accused person goes into custody. He has to suffer imprisonment, either simple, rigorous, depending on how the court imposes, for a number of years. And along with that, sometimes the court also imposes heavy fines. So this is a very important principle in that sense. Now, when I said that the prosecution has to prove the case beyond reasonable doubt, there is also a thumb rule which is followed that if two views are possible on the evidence adduced in a case, pointing towards the guilt of the accused and other to the innocence, the view which is favorable to the accused must be accepted. This is because the prosecution has a very higher standard to prove. The court will not just take up any matter which is placed before it and decide upon it. It has to be proved in the trial. And as I said earlier, the accused is proven innocent. So till that time his innocence is taken into consideration, the court will always accept a view which is more favorable to the accused, which will lead to not to his innocence basically. Then there's a Latin maxim which says that no person should be punished twice for the same offense. This is double jeopardy. A lot of people might have heard that. Suppose if there is a case for which you are being tried, you cannot be retried on that, or there cannot be a similar case and two cases on one ground, unless there are peculiar circumstances, of course. But no person can be punished two times for the same thing. You are given punishment for one crime only once. You cannot be doubly imposed punishment on you. Punishment cannot be doubly imposed on you. Then, of course, there is a right of silence against self-incrimination, which is a part of the Constitution, Article 20, subclause 3. A lot of people who see all these web series and TV shows might have heard in American jurisprudence, I take the Fifth Amendment right. Fifth Amendment right, that is this right, which the accused person cannot be asked to testify against himself. That is what it comes up when it comes to self-incrimination. You cannot ask the accused person to give evidence which would lead to his own guilt being proved. It is the prosecution who has to prove it, not the accused. Then this is a very important maxim, Latin maxim, actus non facet reum nisi mensit rea, which means that an act does not make one guilty unless the mind is also guilty. So just that the offense has taken place, no, there should be a mental aspect to it. That mens rea should be there. We'll just discuss upon it in the coming few slides. So when it comes to commission of a crime, in a traditional sense, there are four stages. The first is intention. As I was just saying about mens rea, the mind should be guilty when it comes to that. Intention is the mental aspect of any crime when it is, regarding any crime. It is not physically visible, it's in the mind. Uh, Mind you, there is a difference between motive and intention. Motive is to push something to do it. Intention is forming of that thought which leads to crime being committed upon doing the further steps. That is preparation, where you actually prepare or collect arms, ammunitions, make some changes, or design your plan or something. Attempt is when you are trying to commit that offense, and when you're trying, when it actually gets committed, if it is successful, then it is definitely a crime. In IPC, very few provisions also specifically make it as a crime when it comes to attempt. At the stage of preparation, few rigorous laws, not the IPC, but some special laws like Terrorism and Disruptive Activities Act, TADA, or some other such, grievous legislations, make preparation also as an offense under the specific statute, not the IPC. IPC generally it is on the commission of the offense, or in a few specific sections where it expressly prescribes about attempt, then attempt is also an offense. Now, when it comes to a criminal case, in a broad sense, it can be divided into three different phases. First is pre-trial, then is trial, which happens before the court. Post-trial is after the court has pronounced its judgment of either acquittal or conviction, and the procedures after that. So pre-trial stage consists of registration of FIR. Of course, we are covering that in a little detail in the forthcoming slides, or a filing of a private criminal complaint till the stage of framing of charge. Now, between the registration of FIR, filing of a private criminal complaint, and the charges being framed, there are multiple stages. The most important is investigation and inquiry. Investigation in our setup, adversarial setup in India, is not done by the court itself. It is done by the investigating agency. The investigating agency under the IPC is the relevant state police. Special acts may have their specialized agencies also, like how PMLA has Enforcement Directorate, or there is CBI as an investigating agency, which comes under the Delhi Special Police Act. There are other agencies also for that, other such specialized investigating agencies also. Then comes the stage of inquiry. Inquiry is very important because it is done by the magistrate upon conclusion of investigation and till the charges are not framed. Now, the very important stage here is taking of cognizance. This is a little technical, very specific part, which I'm going to cover in the forthcoming slides. So please bear with me for that. Then is issuance of process against the accused persons, which means that you are calling upon the persons against whom an FIR or a private complaint is lodged to come before the court. Then lastly is committal, if applicable. So committal, though I have not prepared a specific slide about it, but I'd like to just focus on this for a moment. Committal is a stage where an offense which is not triable by magistrate, which is triable by a court of sessions, which is higher to the magistrate who has taken cognizance passes the matter from his office to the court of sessions, which is a higher office. So this only happens when the offense becomes triable by the court of sessions. So I think I've made myself a little clear when it comes to pre-trial stage. Now let's come on to trial. Upon framing of charge against the accused by the concerned trial court, the criminal trial actually starts. So it consists of examination of prosecution witnesses. As we discussed 2 slides before, the burden of proof for proving guilt of the accused is on the prosecution. Therefore, the prosecution goes first. Then, once the prosecution witnesses are examined, then there comes a very important stage of recording of a statement of an accused person under 313 CrPC. Mind you, when I was saying about right against self-incrimination, this statement which the accused gives before the court is never recorded on oath. The court puts up the questions from the prosecution witness's evidence to the accused, asking him his view on this. Why so and so witness has deposed against you? The witness has said so and so and so and so about you. What would you like to say about that? It gives a chance to the accused to put his version of facts before the court. So it's a very important stage because here the accused actually steps into the box, witness box, and is given a right to speak. Then, after the accused is examined, his statement is recorded under 313. Then there is an opportunity given to the accused persons to bring his or her witnesses. Like how the prosecution is proving its case, the accused also is given an opportunity to call his or her witnesses to prove that he is innocent. Then ultimately, once prosecution witnesses are examined, statement of the accused is recorded, and if there are any defense witnesses, ultimately the trial comes to a late concluding stage where both parties, the prosecution and the defense, that is the accused, make arguments before the court upon whatever material is placed before it, so that the matter can be ultimately decided. And once the arguments are concluded, the court pronounces the judgment. It's not an order, it is a judgment, which means either acquittal or conviction, as I explained some time back. And when it comes to conviction, uh, where the court holds that the accused is guilty, the court will give a separate date, or on the same date will give an opportunity to the accused to make out a case why maximum punishment prescribed under law should not be imposed on you. So that is the sentencing hearing. The hearing with regards to the sentence which is to be imposed on the accused. Now this is what the trial stage was, trial phase was. Then it comes to post trial. Now the trial court has completed the matter and adjudicated whatever the dispute was. Now when you are aggrieved from the judgment, you prefer appeal, revision, execution of and appeal or revision. And when the sentencing order is given that the accused may suffer so and so years of imprisonment, either rigorous or simple, and fine, so that sentence which is imposed is actually he is put to execution, that he has to go back into custody. So that is also at a post trial stage upon conviction. Now this is a very important slide where when it comes to understanding who all are the key players in the criminal case. So firstly, it is the presiding officer of the trial court, that is either a sessions judge or a magistrate. So when you read this, you will come to know that ordinarily under CrPC there are only two types of trial courts, that is sessions court and magistrate court. I am not touching more on specific provisions where there may be a provision to High Court to conduct such trials, but that's a very extraordinary thing which is not followed in a due course. There are specific provisions to it, but not in an ordinary course when the regular cases come before the court. Then second is the complainant, that is the aggrieved person in case of private complaints. As I said earlier, there are two modes to launch prosecution. One is by either launching an FIR, lodging an FIR before the concerned police officers. Second is filing a private criminal complaint before the magistrate for private prosecution. Here the state is not involved as a party. The private complainant fights the case against the accused persons named in the complaint, known or unknown. Then there is original informant. When I was saying FIR is first information report, 154 CrPC. We are going to cover that in a later slides. So the word used is first information report. The person who's giving the information to the concerned police officer is called the informant. So we use the term as original informant when it comes to cases, state cases based on FIR. I have seen that in a few other southern region and the other regions in the country, sometimes they use the word de facto complainant, which technically is not right, but it may be a practice of that court. I prefer using the terminology of original informant. Then there is a victim. Victim is a person who has been aggrieved, who has been injured because of the act or the omission done by the accused person. So victim may or may not be the original informant. Victim is the person who actually suffers a loss. Then, as we were discussing about witnesses, witnesses can be both prosecution witnesses, defense witnesses. These witnesses can be of different categories also. There can be eyewitnesses, there can be technical experts like doctors or forensic experts or whatever. Any person who may support the case is named as a witness, either when it comes to an FIR upon conclusion of investigation in the charge sheet, he is named as a witness, prosecution witness, or when it is a private complaint, the complainant himself submits a list of witnesses before the court that these persons are the ones who will support me in proving the case against the accused persons. Witnesses have a very key role in a criminal trial. Then is investigating officer. So in a case, state case, basically on FIR, the police officer who actually conducts the investigation, on ground investigation of the matter, he is also a very relevant and important party in a criminal case. Then this court Karkoon of the concerned police station for coordination purpose. Court Karkoon is basically an officer of the concerned police station who's deputed to sit in the court and coordinate with respect to the cases which are pending before the court of that concerned police station. So a magistrate court or a sessions court in one courtroom may have more than 2, 3, 4, 5 different police stations. So it becomes very difficult to manage. So the concerned police station deputes one of its officer as the court Karkoon, who does the coordination between what happens in court and between the police station. He is the bridge between the two. Then, of course, when it comes to the prosecution, there is the public prosecutor who appears on behalf of the state. He is the advocate for the state. On the civil side, you have government pleaders, state councils. Here you have public prosecutor. Then the accused persons, the persons who are named in the FIR or in the criminal complaint against whom the aggrieved person, original informant, has lodged the FIR or the complaint, by whose action you are aggrieved, that is the accused. Then the advocate or the counsel for the accused person. Every accused has a right to be defended in court. He engages a pleader, advocate, counsel to plead his case before the court. Now, I am digging deep and directly diving into CrPC. When it comes to CrPC, the Act is 1973, which extends to the whole of India and is applicable from 1st of April 1974. The Act received its assent on 25th of January 1974 and was based on the suggestion of the 41st Law Commission report. So, mind you, even before the present CrPC, there were previous legislations who used to look after the criminal procedural aspects, the procedural law with regards to the criminal justice administration, which was in the year 1898, and it got repealed because this new CrPC came into being. Now, an important object of CrPC that to provide an opportunity to the accused person to get a fair trial in accordance with the principles of natural justice, and to make an effort to prevent delay in investigation and trial to ensure fair justice. You see, there are two times the word fair, fair trial, fair justice, because the criminal case has much more gravity in compared to a civil case. It's not easy to prove a criminal case, as I said, but it is easier to commence the criminal proceedings when it comes to a case instituted on FIR. So the framework of CrPC as we stand today consists of 534 sections, 484 original sections which were enacted, plus 50 amended sections which have been time and again added so as to crop out whatever lacunas were there under the law. Now, this 534 sections have been divided into 39 chapters. Originally, there were 37 chapters. 2 chapters were amended and newly added. And very importantly, the CrPC has 2 schedules along with it. So when you might have gone through the Bare Act, which was posted on the group, after the sections, there were schedules. There were 2 schedules which are in a tabular format. So those are 2 schedules which formally form a part of the CrPC and are looked upon by the courts also. I'll of course come upon it. Therefore, I would request at the relevant point of time, you please take out the PDF. I'll point it out when the relevant slide comes. So when I was saying about CrPC, it has been amended multiple times. 1978, 80, 83, 90, 91, 93, 2001, 5, 6, 8, 10. 13 is the very important one when it comes to about rape victims, Nirbhaya case, if everybody remembers the Delhi incident. And 2018, very recently, there was a amendment. Now, there are few definitions which are given under CrPC, which I would like everyone to ponder upon. Section 2A, bailable offense, means an offense which is shown as bailable in the first schedule or which is made bailable by any other law for the time being in force, and non-bailable means any other offense. This definition doesn't give a clear clue of what a bailable offense is and what a non-bailable offense is. I'll put it in the simplest terms here. Bailable offense is an offense where bail can be taken as a matter of right. Nobody can deny granting of bail to the person who is accused in a bailable offense, neither the police officer nor the court. Now, on the other hand, when it comes to non-bailable offense, don't take it in the literal sense that bail will not be granted. Here, in non-bailable offense, bail is not a matter of right. It is the discretion of the court. So here, the role of the court comes when it comes in a non-bailable offense, whether the accused is fit to be granted bail or not. The court has to adjudicate upon it. Now, second is to be charge. When it comes to charge, the definition doesn't give a clear picture. Charge is basically the court explains what all offenses are committed by the accused so as to make the accused understand for which offenses is he being put on trial to. So this charge is a very important stage, as I was saying earlier also. At the time of framing of charge, after the charge is framed, the trial actually commences. We will discuss more on this in the forthcoming slides. Now, cognizable offense means an offense for which, and cognizable case means a case in which police officer may, in accordance with the first schedule or any other law for the time being in force, arrest without a warrant. When it comes to a cognizable offense, please understand the gravity is a little higher. The punishment prescribed for cognizable offense is not just few months or something, not just a couple of years. It has a little higher value in that sense. So, considering the gravity in the schedule, the offenses are put whether they are cognizable, non-cognizable. When it comes to cognizable, the concerned police officer may arrest the accused person without having a specific direction or a warrant from the magistrate for his arrest. Now, as I was saying, inquiry means every inquiry other than trial conducted under this code by a magistrate or by a court. So, inquiry is the stage which comes in pre-trial phase before the charges are framed. Investigation includes all proceedings under this code for collection of evidence conducted by the police officer or by any other person other than a magistrate who is authorized by a magistrate in this behalf. So investigation, as we all know, is that you dig deep into the matter, you collect evidences, you take statements of the relevant witnesses, you put all the materials which you have gathered and put it before so as to put it before the court. So whatever you are doing from the time of lodging of FIR till the filing of charge sheet is investigation. Judicial proceeding means includes any proceeding in the course of which evidence is or may be legally taken on oath. This is quite self-explanatory. Local jurisdiction in relation to a court or a magistrate means the local area within which the court or the magistrate may exercise all or any of its or his power under this code, and such local area may comprise of the whole state or any part of the state as the state government may by notification specify. Now, the next is metropolitan area. So metropolitan area means an area declared or deemed to be declared under Section 8 to be a metropolitan area. The criteria given under Section 8 is more than 10 million population as per the last census. Then it becomes a metropolitan area. Non-cognizable offense means an offense, and non-cognizable case means a case where a police officer has no authority to arrest without a warrant. When you saw cognizable, the police officer had the power to arrest without a warrant. In non-cognizable, he has no authority to arrest without warrant. Interestingly, now when we are discussing about offenses, offense means an act, a positive act, or an omission where there is a neglect on the part of the accused, which is made punishable by any law for the time being in force, and includes any act in respect to which complaint may be made under Section 20 of the Cattle Trespass Act. Police report. Police report means a report forwarded by the police officer to a magistrate under section subsection 2 of 173. Police report, as we commonly call it, is the charge sheet which contains the entire report of the investigation which the concerned police officer has done, the statements which have been recorded, the materials which the prosecution needs to rely upon uh, to prove the case against the accused are collected together, put into a report format. The conclusion is derived by the concerned police officer that in so and so manner, upon conducting investigation, we have understood that the offense has been committed by the accused person on so and so date using so and so modus operandi. Okay. Then it comes to summons case, a case relating to an offense not being a warrant case. We will see what is a warrant case, just one definition after this. Victim, as I was saying, is a person who has suffered any loss or injury caused by the reason of the act or omission for which the accused person has been charged, and the expression victim includes his or her guardian or legal heir. So the definition of victim, as you can see, it is WA, which is amended, which was amended and added to the CrPC because victim was not earlier predefined when the legislation came into force. Now, warrant case means a case relating to an offense punishable with death, imprisonment for life, or imprisonment for a term exceeding 2 years. So, in short, summons case is where the punishment, maximum prescribed punishment, is up to 2 years. When that 2 years period crosses, the punishment is more than 2 years, which is prescribed under relevant statute, then it becomes a warrant triable case. We will look into it in the forthcoming slides. Now, when it comes to the important aspects which a person needs to notice when an offense has been committed or has occurred. So very important is to understand what the offense is. You need to see the relevant section for that. In that section, there will be punishment prescribed. Why I want to specifically focus on this is because sometimes if there is an offense which has been committed, the gravity of the offense also describes the punishment. For example, if I hit someone with a stick on his or her hand, which may cause injury to him, but not an injury which will lead to a very grievous, part of it. Whereas if I hit somebody on the backbone or on the spine, and he's incapacitated for a certain duration and causes very greater difficulty to him, then that becomes a grievous hurt, which is a specific offense, which is a special type of offense. The ingredients of the offense may be there, but when it comes to gravity, or sometimes even the ingredients specifically expressly provide that it is done in so and so manner or so and so injury is prescribed. So very important is to see the punishment which is prescribed. Then whether the offense is cognizable or non-cognizable. This comes in Schedule 1. if it is regarding IPC offense, in Indian Penal Code offenses, if there's a special act, the special act will prescribe for it in its relevant provision, or else we see the second schedule. We are just going to see that in the next slide. So when I say about cognizable, it means the police officer can arrest without a warrant. Non-cognizable, he cannot. Then whether the offense is bailable or non-bailable, this also we have to see the schedules or the relevant provision. So when it comes to bailable, as I was saying earlier, the bail is a matter of right. Nobody can deny granting of bail. It is obligatory on the part of the court to give you bail. Non-bailable is discretion of the court considering the nature and facts and circumstances of the specific case. Then comes this offense is triable by which court? As I was saying earlier, there are two courts, Sessions Court and Magistrate Court. So the schedule very specifically puts up which type of which court tries the matter, or sometimes where there is a special court established for the trial of the specified offense. So we have to see the schedule 1, 2 or the special act provision. Now type of trial, this I will be explaining in the forthcoming slides. This is very relevant when it comes to conducting of the matter actually in court, when the trial uh, actually takes place in the court, where the whether the offense is compoundable or non-compoundable, we have to see section 320. Compounding is a provision where both parties come together by consent, say that there is no fruitful use to continue with these proceedings, we will settle out this matter. So the provision in 320 specifically prescribes some of the offenses which are compoundable in nature, where both parties come together before the court, the complainant, the aggrieved person, or the first informant in that case, and the accused, they place the facts before the court that there is no fruitful use of continuing with the trial and we are settling the case, to just put it in simpler terms. Okay, so now as the PDF of the CrPC was shared, I would like everyone to just open it on the group and just check the PDF file. In the previous slide, we were seeing everywhere that first schedule, second schedule. I have put this extract from the CrPC barrack. You may open page number 216 of the PDF file which was shared on the group. The first schedule will be displayed. I hope everyone is able to locate that on the group and open the relevant page number 216. So first schedule is regarding the offenses under the Indian Penal Code 1860 IPC. There are two explanatory notes. The in regard to offense under IPC, entries in the second and the third column against the section number, where the first column is not intended. Punishment prescribed under offenses is merely indication of the substance of the section. It is not the reproduction of the entire section in this. It just briefly covers what is covered in that relevant offense which is there in the concerned section. Now, magistrate of first class, any magistrate includes metropolitan magistrates, but not executive magistrates. So, in CrPC and even in otherwise, we have seen that the specialized officers, IAS, IPS, are given powers as executive magistrates. They are appointed by the concerned state government to exercise certain powers. Uh, they are not metropolitan magistrate, they are not judges, they don't sit in any courtroom as such. They are regular IAS, IPS deputed officers, but are exercising certain specified powers either under CrPC or under various statutes, which which they are appointed by the concerned state government. Cognizable stands for police officer may arrest without warrant. Non-cognizable is cannot arrest without warrant. Now you see there are 6 columns in this. First column is the section number. Second is the offense, which is put up here in very brief manner. Third column is the punishment which is prescribed for that offense. Fourth column is about cognizable or non-cognizable, which, as we just read some time back, cognizable means arrest with a police officer may arrest without warrant. Non-cognizable means he cannot. And bailable or non-bailable, as I was saying earlier also, bail is a matter of right. In case of bailable offenses, the court is duty bound to give you bail. Non-bailable is the discretion of the court. Court by which the offense is triable. This is what I was saying, that we have to understand when it comes to an offense, by which court, either by the metropolitan magistrate or the judicial magistrate first class, or by the court of sessions. So this slide was only to show that there are 6 columns. I hope everybody is being in touch and is able to understand. I'll give a practical demonstration in this slide. You may please try to find 498A provision in that schedule. Sorry, I have not written the page number of that. You may search in the schedule. When you go towards the end, 498A, you will find this same schedule. I have taken a relevant screenshot. 498A, as people are aware, is an offense by which the husband or the in-laws of a married lady are punished for causing cruelty upon her. Uh, so this was section number. This was the offense. This is the punishment. Third column is the punishment. Punishment prescribed under the Indian Penal Code in 498A, which is chapter 20A, is imprisonment for 3 years and fine. The third column gives us an idea with regards to punishment. Fourth is whether it is cognizable, non-cognizable. Cognizable if information relating to commission of offence is given to the officer in charge of police station by the aggrieved person or by any of her relatives or by any public servant in that behalf. So 498A is the offence which is cognizable in nature, by which the police officers may arrest without warrant. Non-bailable, fifth column, when you see, non-bailable means the bail is to be granted by court at its discretion. It is not a matter of right for the accused to claim bail. The court has to decide in the facts and circumstances of the peculiar case. This type of matter is triable by the magistrate of the first class. Okay, this was 498A. I am also doing one example of another provision, which is defamation. As everybody knows, making false statements about a person which harms his or her reputation. So when it comes to defamation, the substantive provision which prescribes the offense is 499, which is not shown in the schedule because the schedule only speaks about punishment related provisions. The definition is given under 499, that you'll have to open the relevant IPC Barak and see. 500 punishment for defamation is of 2 parts. One is when the defamation is made against the president or vice president or the governor of a state or administrator of union territory or a minister in respect of his conduct while discharging his public functions. This when instituted upon a complaint made by the public prosecutor. The punishment prescribed is simple imprisonment for 2 years or fine or both. This type of offense is a non-cognizable offense. The police cannot directly arrest you when the offense has taken place. Like in case of 498, how we saw cognizable, the police cannot come directly and arrest you. then this offense is bailable. So you can claim bail as a matter of right. When it comes to the defamation made against the specific president, vice president, governor, these are all higher authorities which either act as constitutional authorities under the or as appointed elected members of the people. Therefore, this the gravity of such case is higher, which is triable by the court of sessions. Now, defamation against any other person in any other case, the punishment is same, 2 years or fine or both. Same, it is non-cognizable. No police officer can arrest. Bailable also it is same, but it is triable by the magistrate of first class. So you see that the schedule 1 is so relevant to understand when it comes to the offense of defamation. If you would have not seen this and just by going through the IPC Bear Act and not seeing the first schedule of CrPC, you would have not understood that the classification of the offense is under two parts, which are triable by two different courts. Okay. And just to touch upon, since we are discussing more on defamation, there is another provision under CrPC 199 CrPC, which says that only the aggrieved person can file a complaint. Aggrieved person means himself, or when the person against whom such statements are made is a deceased person, his or her legal heirs can institute a complaint before the magistrate. This will be a private complaint. There is no FIR in that case because it's a non-cognizable offense. Okay. Now, this was about first schedule. In the CrPC, after the first schedule was regarding IPC offense. Second is classification of offenses and against other laws. Where you saw in the previous slide, there were 6 columns. Here, there are 4 columns only. First is offense with whatever punishment is there. Second is cognizable or non-cognizable, bailable or non-bailable, and by which court it is triable. So, if the punishment for that relevant offense under special law, the name of any specific law is not given here because this is made as a general when it comes to specialized law. Of course, that relevant statute may give out its own punishment or the method of trial, but if it is silent in that respect, then you follow the second schedule. So, if the punishment prescribed under the special law is with death or imprisonment for life or imprisonment for a term more than 7 years, it is a cognizable where magistrate may, the police officer may arrest you without a warrant. It's a non-bailable where the court has discretion to grant you bail, not as a matter of right. And this type of offense is triable by the court of sessions. When it comes to offense which is punishable with imprisonment of beyond 3 years, but up to 7 years, it is cognizable, non-bailable, but it is triable by magistrate of first class. If the offense is punishable with imprisonment for less than 3 years or with fine only, then it is non-cognizable. Police may not arrest you directly without a warrant. It is bailable. You can claim bail as a matter of right, and it is triable by any magistrate. Okay. Now, when I was saying magistrate court, sessions court, we need to understand the hierarchy of the courts. So, when you see the topmost pillar in this is the Supreme Court of India. Supreme Court of India is not a trial court. Supreme Court of India is the highest apex court in the country, is the highest body to decide any appeals when it comes to any criminal matter or even in civil matters in that case. Then below Supreme Court is High Court, then there is Sessions Court, and then there are magistrate courts. Okay. So Supreme Court can grant any sentence authorized by law. So there is no specific section of CrPC mentioned here because uh, the Supreme Court only entertains appeals. So Supreme Court in that sense can grant any punishment authorized by law. There is a specific provision under the Constitution, Article 134, if I'm not wrong, and SLP 136, when there is a appeal to be preferred from the High Court, it goes to the Supreme Court. So the Supreme Court, in that sense, can grant any sentence which is authorized under the law. Also, there is a special act for Supreme Court Enlargement of Criminal Appeal Jurisdiction Act 1970, which again prescribes that the Supreme Court can grant any sentence under the law. High courts, section 28(1) can impose any sentence authorized by law. So in a similar footing to Supreme Court, the high courts can also grant any sentence to the accused persons under the law. Mind you, high courts, very rare exceptional circumstances, conducts trial. High court is also a court of appeal. In criminal side, very rarely you may see original criminal side where the high court becomes the court of first instance. In 99% circumstances, when an appeal comes to the high court, there are proceedings before pending before or conducted before the lower courts. Okay. So then there is sessions judge or the additional sessions judge, section 28(2). He may impose any sentence authorized by law except for the sentence of death, which requires confirmation of High Court under 368. So a sessions judge has the power to impose any punishment under law, may it be life imprisonment up to 5 years, 10 years, fine, or anything. Only in case of death, he or she may impose that, but requires a confirmation to be taken by the High Court by making a specific reference. Then below the sessions judge is the assistant sessions judge, section 28(3), who may impose punishment up to 10 years or fine. So when the matter is triable by the sessions court and the punishment is given up to 10 years, it can be tried by an additional sessions judge. But where the punishment prescribed under law is more than 10 years, then the assistant sessions judge cannot grant such punishment. It has to be granted by the sessions judge or the additional sessions judge. Then there is chief judicial magistrate or chief metropolitan magistrate, 29(1) and 4. Both are on the same footing. It's just because certain areas are classified as metropolitan areas, certain are not. So when it comes to metropolitan area, you have chief metropolitan magistrate. When it is a non-metropolitan area, you have chief judicial magistrate first class, the CJM or judicial magistrate first class, just below it. So it can impose punishment up to 7 years. The judicial magistrate first class, JMFC, or the metropolitan magistrate in metropolitan areas can impose punishment up to 3 years and or up to fine up to 10,000 rupees. The judicial magistrate of second class, 29(3), may impose punishment of up to 1 year and fine up to 5,000. To be very honest, these courts are now practically not there. Every power is now either before a metropolitan magistrate or a chief metropolitan magistrate. Very few offenses up to 1 year punishment is prescribed, though on a practical on ground field, even the metropolitan magistrate is empowered to give it. Okay. Now when I was saying types of trial, I have tried to make a table so as to understand there are majorly 4 types of trials given under the CrPC: summons trial, warrant trial, sessions trial, and summary trial. So summons trial, there are 2 types of special summons trial. One is either on a police report, which is the charge sheet is filed by the police upon conducting investigation, and otherwise is by a private complaint. So in Bombay, we use the terminology of the case as PS when it is police case, summons trial, PS. When it is a private case, we use SS. First is for private and second is for summons. So here the punishment prescribed under law is up to 2 years. As we had seen, summons case and warrant case, any offense for which punishment is beyond 2 years is warrant triable, where it is up to 2 years is summons triable. So this is triable by the magistrates court. Warrant trial, as I was saying, about 2 years up to 7 years. Now, as earlier, police report and private case. So police report is the charge sheet case. We call it as PW. Private case, we call it SW. So this is on the FIR investigation is conducted. So it is on police report. Otherwise is on a private complaint which is made by the aggrieved person. This is also triable by the magistrate court. I have tried to note down the sections. You all may kindly take a screenshot if you want. Otherwise, I'll try to share the PPT after the session. Then the third type of trial is sessions trial. Here, the court of sessions, that is the sessions court, conducts the trial rather than a magistrate court, because you see the punishment is above 7 years and up to life imprisonment and death, subject to the confirmation from High Court. Okay, so this is sessions trial. The gravity of the offenses which come to sessions court for trial are very severe. So murder trial or a rape trial come before a court of sessions. Minor cheating or defamation or certain other offenses come before a magistrate where the punishment is not that grievous. Then there is summary trial. So it follows the same provision of summons trial. Punishment is also up to 2 years, but it is for a specified petty type of offenses which are given under the CrPC. Minor theft and certain other specific provisions. When it comes to, I would like to explain one example. When it comes to special acts, I'm not discussing about IPC. This is special act where, for example, the offense of check dishonor of check under 138 Negotiable Instruments Act. Ideal provision which is prescribed under the Negotiable Instruments Act is summons trial. It is before a magistrate. It follows the summary trial procedure. Summary trial procedure is followed because the Negotiable Instrument Act specifically prescribes summary trial. So the magistrate then therefore applies summary trial provision. This is majorly for classification of types of cases. Okay, which of course has a role to play when it comes to trial. The provisions of CrPC are very different for each of them. I will share this slide or you can take a screenshot. I'll hold on for a minute. Okay, I'm proceeding. So now that we have seen a bird's eye picture, the first question which comes is, how does a criminal case start? How does it commence? So as we were saying, cognizable offense means an offense where the police may arrest without warrant. There the provision of FIR is provided under the CrPC. So when it is a cognizable offense, means there has to be an FIR. It is the bounded duty of the officer in charge of police station to register an FIR if any information regarding cognizable offense is given. This is prescribed under 154(1) of CrPC. When you see an actual FIR before you, you will see the form says first information report under 154(1) of CrPC. The police officer maintains a diary of FIRs. He by hand, or now because of digitization they have started typing it out, but they have a very specified structural format which they follow at the time of registration of an FIR. If the cognizable offense is there and the person is the first informant or the original informant is making the grievance to the officer in charge of the police station, and if that police officer fails, then the aggrieved person can send his or her complaint in writing. So first information report can either be by writing a letter to the concerned police officer, the officer in charge, or the senior inspector of police, how we refer to him, or the station house officer as it is called, or by orally giving the information. But if that officer fails, then you can write your complaint you give the complaint in writing to the superintendent of police, SP, or in a commissionerate system, the DCP, deputy commissioner of police, who may direct the subordinate officer to investigate and register the FIR if cognizable offense is made out. 154(3). So the CrPC itself prescribes that when there is a dereliction of duty on part of the police officer whose bounded duty to take up to register the FIR, the remedy for that is to complain to the higher authorities, that is the superintendent of police, or in commissionerate system is the deputy commissioner of police. The CrPC itself provides that when that superior officer has a power to direct the subordinate officer to register the FIR. Now, when still after following these two, when you visited the police officer, concerned police officer, his senior officer, still there is no FIR, then the aggrieved person can approach the concerned magistrate exercising the jurisdiction with a private complaint in writing with a prayer to direct the police station to register an FIR and investigate the case. This is under 156(3). Now, why you are going to the court, to the magistrate, to say that, see, I have given the complaint to the concerned officer, I have written the complaint and given it to the senior officer, but still no action is being taken. I am aggrieved by this. You are requested to take cognizance of my written complaint and direct the police to investigate and register an FIR. So, when I was saying that about first informant, original informant, and the victim, it is not mandatory for the victim or the aggrieved person to lodge the FIR. Any person who has witnessed the incident when such offense has been committed can provide information to the police officer, and if it is a cognizable offense, then FIR would be lodged. So it's not necessary. Suppose you are hurt and you are not in a position to explain the how the offense has taken place. Any person who has witnessed this firsthand can go and give the information to the police officer and register the FIR. Okay. Therefore, the terminology uses first information report is because it is first in time it is received before the officer so as to take immediate action. So, objective of lodging of an FIR is to inform the police officers by giving necessary information first in time of commission of a cognizable offense so that they can investigate the case and trace the accused. It is a step to set the criminal law into motion. So, without an FIR in a cognizable case, no police officer will directly start investigating, arrest the accused, or collect evidences. It is mandatory to lodge the FIR first. The FIR contains the statement of the person who's giving the first information about how the offense has been committed. It may not be too much in detail, but it should make out a case that there's a cognizable offense is made out. A telephonic call giving tip or an information is not an FIR. Only a statement given to a police officer which is reduced in writing shall become an FIR. FIR is not an encyclopedia. Relevant facts disclosing commission of non-cognizable commission of cognizable. Sorry, I have written non-cognizable typographical error. Cognizable offense must be written. No two FIRs against the same person for the same offense is permissible, as we had seen in the principles that no person can be punished twice for the same offense. This follows the same principle here. The only exception is cross case, where the aggrieved person, the first informant, original informant in one case, who's lodging the FIR against the accused, in the other case, the accused can lodge a counter or a cross FIR against the informant in the first case. Okay. FIR need not necessarily name the person, accused person, if not personally known to the informant. It can be against unknown persons also. FIR is relevant for corroboration purpose when the original informant is called before the court to give his or her testimony. Okay, so FIR doesn't automatically become a relevant piece of information. Only it is only as a corroboration when the when the original informant is called before the court, he or she steps into the box and deposes before the court on how the offense has been committed, how the FIR came into being. Now, there's a very important judgment of Lalita Kumari, which was given by the Supreme Court. I'll just briefly touch upon it. I'll be sharing the slides so you may go through it in a little detail. That it is mandatory to file an FIR if cognizable offense is made out. If the information doesn't reveal cognizable offense, but it suggests that investigation is required, formal investigation may take place. Upon that investigation, if it reveals a cognizable offense, then it is mandatory for the police officer to register the FIR. If not a case is made out, then closure must be there. There must be an entry made in the diary, and this should be done not more than 1 week. Okay. In certain cases, the preliminary inquiry is required, especially when it comes to matrimonial disputes, family disputes, 498A, as we were seeing, commercial offenses, especially when it comes to about cheating in businesses, then there requires to be done some preliminary inquiry. Medical negligence cases, corruption cases, of course, corruption cases, there the Special Act, Prevention of Corruption Act 1988 prevails over this, general law. So in that case, there are other steps also to be taken. Cases where there is abnormal delay in initiating criminal prosecution. Always remember that the information which is given first in time when the offense has occurred, or when it is, within a reasonable time, it should not be without a delay. If there is a substantial delay, the police officer is bound to see how and why there is a abnormal delay. As a defense attorney, I have to see and prove a case to the magistrate or the sessions judge that you see the date of the offense and you see the date of FIR. If there is a substantial delay, this can be as an outcome of pre-planning or uh, mixing up of stories and concoction of actual facts which have taken place. So there is always a scope of you know uh, um, how, what do you say, of making out a false story and painting the accused person into a wrong picture and deliberately lodging an FIR. So therefore, where there is a delay, the police officer has to conduct some preliminary inquiry. Of course, this list is illustrative, not exhaustive. The conclusion of preliminary investigation shall not exceed 7 days, and all records should be maintained. The general diary entries and registers should be maintained. Okay, I'm just rushing a bit because we have got few more slides to complete. Okay, when we saw about cognizable offense, now what about non-cognizable offense? Non-cognizable offense, the police is not bound to register an FIR. There is an NCR, non-cognizable report, which is filed. A diary entry is made in the concerned register because it's not a cognizable offense. And in this case, without the direction of magistrate, the police cannot investigate. He cannot arrest, he cannot investigate. He just has to make a formal entry in the concerned diary and give you a NCR that so and so time, so and so person has lodged the complaint against so and this is the brief facts. Only remedy with the aggrieved person is to approach a magistrate by filing a complaint in writing. The aggrieved person, the actual victim, may also prefer filing a non-cognizable offense in a private complaint under 200. As I was saying, there is always a provision of filing privately prosecuting by filing a written complaint before the magistrate under 200. If the offense consists of both cognizable and non-cognizable, then it will be deemed to be cognizable and FIR will be registered, meaning it will become it will be prosecuted like a state case instead of a private prosecution, what we saw in the previous slides. Okay, as we were discussing about private complaints, 2D defines complaint as any allegation made orally or in writing to a magistrate with a view to taking action under this code that some person, whether known or unknown, has committed the offense, but does not include a police report. Police report, as we were saying, is the charge sheet 173(2). Explanation: a report made by the police officer in a case which discloses after investigation the commission of a non-cognizable offense shall be deemed to be a complaint, and the police officer by whom such complaint is made be deemed to be the complainant. Okay. A private criminal complaint can be filed by the aggrieved person before the concerned magistrate for non-cognizable offense, and he shall be examined on oath under 200 CrPC. The classic example for this, as I was saying earlier, is the offense of Negotiable Instruments Act. The check is dishonored. The drawee in whose favor the check was given, he privately prosecutes the drawer of the check by filing a private criminal complaint under 200 read with 138 Negotiable Instruments Act. Okay. Now the important aspect about arrest. Okay, the arrest is the word which is derived from the French word arrêter, means to stop, and signifies restraint. The word arrest, when it is used in natural sense, means apprehension or restraining a person's liberty. So the essentials to constitute an arrest means that there has to be an intent to arrest under the authority, accompanied by seizure or detention, seizure of detention of a person in the manner known to law, and the same should be understood by the person arrested. So this very categorically distinguishes arrest from detention. Detention is a preventive measure where there is no formal FIR as such registered, whereas in arrest there has to be an FIR or a direction given by the magistrate to arrest. Okay, before making an arrest, there must be reasonable apprehension that the person may have committed the offense. You can't randomly pick up any person against whom there is no apprehension that he may commit the offense. The specified person should be identified, and there should be a reasonable apprehension that this person may have committed the offense under the information given as per the FIR. Why is arrest necessary? For securing the attendance of accused person at trial as a preventive precautionary measure. Here preventive measure is so that he or she doesn't tamper with the evidence during the stage of investigation when refusing to give his name or residence. Of course, there is a specified offense for that, and specific provision is given even under the CrPC, where the person is refusing to disclose his or her identity for retaining a person escaped from custody. Okay. Now, who can arrest? There are 6 types of persons who can arrest. Police officer may arrest without a warrant, under a warrant, or under the written authority of the officer in charge of police station, or specifically under the orders of a magistrate, and in case of non-cognizable offense by the specific order given by the magistrate. These superior police officers, as we were saying, the SP, DCP, or some other officers may exercise these powers as a police officer. An officer in charge of police station or the station house officer, as commonly known, can also exercise all of these powers. A magistrate is also empowered to arrest a person. Okay. A military officer in specified circumstances given under 130 and 131 may arrest any person. Okay. A private person, any citizen, non-citizen can arrest without a warrant when specifically when there's a cognizable offense being committed in his or her presence, so as to immediately inform the police officers and take him into custody, or under a warrant specifically by a magistrate, or under the orders of a police officer, where expressly a police officer is directing you to arrest that person, or under the orders of a magistrate, where the magistrate has empowered you to arrest any specified person. Okay. Now, how does an arrest actually take place? Arrest, how it is made is given under 46. You should actually touch or confine the body of the person who has to be arrested unless he submits to custody by his word or action. He may either surrender, hold his hands up, or tell that I am ready to accompany you. You may arrest me. Okay. When there is a woman, a police officer, a female police officer may arrest the female accused person. A male officer cannot. If the accused person forcibly resists the endeavor to arrest him or attempts to evade, then the police officers may use necessary force to effect the arrest. Okay, but nothing in this provision shall give a right to cause death of a person who is not accused of an offense punishable with death or imprisonment for life. So if you are being arrested for an offense which is not offense punishable with death or imprisonment for life, and you are trying to escape, no police officer can has a right to cause death in that specific circumstances. Now, save as in exceptional circumstances, no woman shall be arrested after sunset or before sunrise unless in very specified circumstances the woman police officer, by making written report and obtaining prior permission of the magistrate concerned. Okay, there are duties also which are casted upon the officer who's making the arrest. Every police officer making such arrest shall bear accurate, visible, clear indication of his name, so as to understand who is this officer who's arresting me. He shall prepare a memorandum of arrest. It's a written document which is prepared, which needs to be signed by at least one witness who's a member of the family or respectable member of the locality where the arrest is made, or and the same is to be countersigned by the person who is arrested. Ideally, in practical scenario, there are photograph is attached, his thumbprint is taken, his signature is taken, his details are put up in this form. Arrest form is separately made, and such person, the arrest memo shall be attested by a member of family, and he has a right to have the relative informed about his arrest. Another obligation which is casted upon such officer is to inform the nominated person of such arrested person uh, about his arrest and his rights when he is brought before the police station. I'll just move on a little because this is a statutory provision. You can read it in the provisions also, and I'll also share the PPT. Rights of the arrested person. 41D. The right of the arrested person to meet an advocate of his choice during interrogation. So when the person is arrested and is being interrogated by the police, he shall have the right to meet his advocate of his choice during an interrogation, but not throughout the interrogation. This is a very specific uh, case where not during the entire interrogation period that the advocate will be allowed to meet and consult with the accused person. He will be kept within earshot distance. It is not mandatory that he should be sitting next to the accused person, because the accused person is taken into custody and is being interrogated. Okay, the accused has a right to call his advocate and inform and give specific details about the case, but it is not throughout the interrogation. He he can give the information. That right is being provided to him. Person arrested should be informed about the grounds of his arrest and the right of bail. When it comes to a bailable offense, the police officer has to inform that bail is a matter of right. You can take bail, uh, and the police officer has to inform about this, that this right exists in your favor to the accused person. Now, the person arrested, 56 and 57, when you read it combinedly, uh, has upon being arrested has to be taken to the nearest magistrate, where the local area jurisdiction magistrate, within period of 24 hours, except for the traveling time from the police station to the magistrate's court, so as to be produced before him, and he has to decide whether to keep him in custody, either police custody for interrogation, or commit him to judicial custody, in that sense. He cannot be kept in custody for more police custody upon being arrested for more than 24 hours. He has to be produced before the concerned magistrate within 24 hours. Right to be examined by doctor, of course, medical professionals, doctors come and take whatever details are there of the accused person. Right to free legal aid. So if the accused person is unable to procure a pleader or an advocate for him, the state at its own cost provides legal aid, free legal aid to the accused, and representative advocate is appointed for the accused so that there is a fair hearing which is given to the accused person during the matter which is pending before the court. It may be at the stage of bail or may be at the stage of trial. Okay. Right to consult the legal practitioner of his or her choice, 303. This is he has a right to consult his or her specified lawyer. He may say, I want this or this lawyer. It Nobody can stop him in that sense. But when he cannot afford, the state can provide legal aid. These are few cases regarding arrest, which are very landmark in its sense. Arnesh Kumar, where no mechanical arrests are to be made. The provision of 41A is to be, a notice has to be given to the accused person to be called to the police station where the offense is cognizable but punishment is less than 7 years. He's given a notice. You come and attend before the concerned police station because there's an FIR lodged against you. Then there is Joginder Kumar, inform a friend or a relative about the arrest and entry to be made. This is already we saw there was an amendment by which it was taken into the CrPC. Khatri is about legal aid 304, which we saw. DK Basu gave guidelines for arrest, which are now incorporated. What we saw 41, 41D, and the other provisions which we saw earlier. Now, this Nilabati Behra, this case is regarding when a person was arrested and kept into custody, and he was in the custody. He was given so much of torture that he died. So his legal heirs filed a case before the court seeking compensation for custodial death of the accused person. Now, when we spoke about arrest, the immediate next step is bail. Word custody means apprehending someone for protective care. The principle behind arresting a person suspect of a crime. Therefore, I was saying accused person, not a convict. Accused person is to save from the other people in the society. Now, the concept of remand. Remand signifies process of committing and detaining the person accused of a crime in judicial custody under the authority of law for the purpose of investigation and trial of a case. The purpose of remand under 167 is when the investigation cannot be completed within 24 hours, the accused may be remanded to custody. Now, the custody here is of two types: is of police custody or judicial custody. Police custody is the actual lockup, police lockup, which is there in the concerned police station, uh, whereas judicial custody is the prison or the jail of the concerned state or the center, depending on which type of offense. When the accused is put into police lockup, and whereas in judicial custody he is in jail, the limit for police custody shall not be exceeding 15 days, and judicial custody there is no outer limit as such. Bail is release of a person to submit a personal bond or assurance to comply with the conditions imposed by the court and to appear before the court. So bail is basically when the court grants bail in its discretion, seeing the facts and circumstances of the case, imposes certain conditions. He shall not tamper with the evidence, he should not influence the witnesses, he shall not travel abroad, he shall attend police station if the charge sheet is not yet filed. These are general conditions which are imposed. So he is bound to follow that when the court grants bail. Apart, if he fails to follow these bail conditions, then the state may move for cancellation of his bail. Just because a person is accused of a crime, an endless period holding the person for an endless period in custody cannot be the only option. Therefore, bail has to be granted. Bail involves both aspects, balancing of both aspects, individual freedom as well as the threat to the society. So, therefore, the courts have to apply their mind and therefore grant bail. Now, under CrPC, there are different types of bail which are prescribed. Bail in bailable offense 436, where I was saying bailable offense means bail is a matter of right. Non-bailable offense, there are two specific provisions, 437 and 439, where it is the discretion of the concerned court whether to grant you bail or not, seeing the facts and circumstances of the specific case. 437, when it is court other than High Court or Sessions Court, that is the magistrate's court, and when it is a magistrate's when it is before the High Court or the Sessions Court, it is under 439. The powers are just divided in these two specific provision depending on the court. Magistrate court 437, Sessions and High Court 439. This is in case of non-bailable offense bail. Now there is a concept of anticipatory bail, also sometimes known as pre-arrest bail, where before you are arrested, you take an order from the court that in the event of arrest of so and so person in connection with this FIR, he may be released on bail on granting so and so amount of sureties. Okay. So this power of granting anticipatory bail is not when actually the person is arrested, but is apprehending arrest. So anticipatory bail can be granted by either by the Sessions Court or by the High Court. Now there is a provision for default or statutory bail under 167(2). So when it comes to statutory bail, the investigation under 167 prescribes when it is not completed in 24 hours, he may be committed to custody under remand, either PC police custody or JC judicial custody. There is an outer limit to conduct the investigation. The CrPC prescribes that up to 60 days for offenses which are punishable less than 10 years. When there is more than 10 years, life, death, then 90 days outer limit is given. If during this period from the date of arrest till the filing of completion of investigation, filing of charge sheet, this period has gotten over and the accused is still in custody, he has a right to be released on bail. This happens in case of statutory bail. Now, bail in case where the accused has suffered more than half of the sentence prescribed for the offense, that is 436A. So, for example, uh, in case of defamation, for suppose the accused is it's a suppose if it was a non-bailable offense and he was taken into custody and he was kept into custody for more than 1 hour, 1 year, then the punishment prescribed is 2 years. Then he would have applied under 436A because he has already suffered half the sentence prescribed for the offense, maximum prescribed punishment for the offense. Now, bail which is required to appear before an appellate court 437A. In this case, the trial has concluded, the accused has been acquitted, but due to the period of limitation for appeal, 6 months period is there, the court takes a bond from the accused so as to comply that he will appear before the appellate court. And when there is an appeal, if the accused is still in custody, if he is convicted and he is still in custody, and if he wants to be released on bail, that is bail during pendency of appeal 389, which is a classic example. Recently you might have seen of a very well-known politician in a defamation case. The Supreme Court ultimately granted bail and suspension of the sentence under 389. Uh, Unfortunately, I have not added any specific slide for specific cases, landmark cases for bail, because bail as a subject, I can take it up as another session also. But on the top of my head, I can say 2, 3 specific judgments. Satyendra Kumar Antil, which is very recent by the Supreme Court about bail. Kalyan Chandra Sarkar is a judgment of the Supreme Court about successive bails, where despite filing of the previous bail application which was rejected, when can the subsequently he apply for bail? Then Gurbakh Singh Sibia for anticipatory bail 438A. Then for statutory bail, there was a judgment of Uday Acharya, if I'm not wrong. So there are other landmark judgments also. Chidambaram's judgment, bail is a rule, the jail is an exception, and various other judgments. So due to paucity of time, I'm not covering much in detail. We have to proceed further. Now, the procedure till now we have understood about FIR, investigation, arrest, bail. Now, when the investigation gets completed, the police files a charge sheet 173 to final report form, or it is also sometimes called as challan in other parts of the country. So, upon the filing of that final form, a case is put to number. In case of state cases were instituted on FIR, when it comes to case instituted on private complaint, after, upon lodging of the written complaint, a case number is given, and the magistrate in that case has to apply his or her mind to the facts of that case to analyze whether a case is made out, whether these facts disclose commission of an offense. So when that is being done, that is called as taking of cognizance. So basically, it is taking judicial note by the court of law possessing jurisdiction on the cause or the matter presented before it, so as to decide whether there is any basis for initiating proceedings and determining for the cause or a matter judicially. Cognizance is taken prior to commencement of the proceeding. It is sine qua non, or it is a condition precedent for holding a valid trial. It's a settled law that cognizance is taken of an offense, not of the offender. So cognizance is application of mind to the complaint or the charge sheet which is presented before the magistrate or the sessions judge in that case. Uh, sorry, magistrate in very specifically, where he or she applies his mind to the facts of the case, where to understand where the case is made out. So taking of cognizance is judicial application of mind by the magistrate to the facts mentioned in the complaint to with a view to take further action. Now this section 190 prescribes how the magistrate may take cognizance, but does not give when he can take cognizance or what is the procedure for taking cognizance. It just broadly classifies four types where magistrate may take cognizance. So four sources on the basis of which magistrate may take cognizance is upon receiving a private complaint 2D, which we already discussed earlier, a police report, that is charge sheet or the challan final report form 173(2), or in two other scenarios where information is received from any person other than the police officer. Example, a news item in the print media, electronic media, or on the internet. He may take suo motu cognizance in that sense, or when it comes to the knowledge of the magistrate where the offense is committed in his presence. Now, cognizance in any case is generally taken by the magistrate. The Sessions Code 193 says is expressly barred from taking cognizance of any offense unless the case is committed to it by the magistrate. What we saw 209 provision earlier is when the magistrate has to make out the case, he has to take cognizance, provide copies to the accused person, and then send the papers of this case from the magistrate's court's office to the sessions court. It's an administrative function in that sense. Now, when the cognizance is taken, here till now it is only the complainant, unless there was arrest, bail and all, the accused person would appear. Otherwise only the complainant in complaint case, original informant in FIR, and the public prosecutor in that case are a party to it, to call upon the accused to remain present before the court so as to proceed with the case. The court issues summons or warrant. In when it cognizance is taken, the magistrate doesn't enter into detailed discussion of merits or demerits of the case, but only says that there's a probable chance that the offense may be committed. I've applied my mind to the facts of this case, therefore I'm taking cognizance, and then the next stage is to issue process. Now, issuance of process in summons case means he will send summons to the accused to attend. In a warrant case, he may send warrant or summons as he deems fit to appear before him, that concerned magistrate, or if he doesn't have jurisdiction, to other magistrate having jurisdiction. And no summons or warrant shall be sent unless a prosecution witnesses list is submitted. In any proceeding instituted upon complaint, every summons or warrant shall be accompanied by such written complaint, and process fees must be paid. This, of course, is nothing should be effected under 87. 87 is specific for in a warrants case. Directly a warrant may be issued where there is an apprehension that the accused may abscond, or when a previous summons was sent in a warrant triable case, but he has failed to remain present before the court. So the court has powers to issue warrant. So that is given under 87. Now, important is supplying documents to the accused person. A accused person has a right to be knowing of what accusations are being made against him. He has to be shown what documents the prosecution is relying to make the case against him. So, as a complete fair disclosure for a fair, open, free, fair trial, he has to be provided with all these documents, all witness statements, the final report form, the FIR, the other documents which the prosecution wishes to rely upon. Now, the object of this section is to provide with the documents for which the prosecution is relying upon to make out the case against the accused, providing the accused with the opportunity to defend himself. And the accused becomes aware of the charges and the material brought against him, thus giving him an idea of what he will be facing in trial, so that he can make his own defense ready. Okay, the provisions are under 207 and 208. I'll be circulating this PPT, and also the CrPC Act is already shared, so you all may refer to it. Because of paucity of time, I'm not going into detail as of now. Now, very important stage comes is that of framing of charge. As I had said earlier, framing of charge is the stepping stone towards the trial. So once the charge is framed, the trial actually commences. What is charge? Charge is basically where the person is explained, the court reads out and explains what case is being put against the accused. So the accused person is being made aware of what accusations are put to him. The court, uh, basically the charge serves as a purpose of notice or intimation to the accused, drawn up according to the specific language of the court, giving clear and unambiguous precise notice of the nature of accusations made against him to meet in the course of trial. So the charge is basically a very fundamental stage in a criminal trial, because once the charge is framed, the actual trial commences. It's a foundation in that sense. So once a charge is being framed, uh, the recording of a plea takes place. So plea of the accused happens in two ways. Either he pleads guilty, that I accept that I have committed the crime. The court may therefore impose punishment according to the provision, or he says that I plead non-guilty, I may be tried for this offense. Now, when it comes to pleading guilty, there is a specific provision, chapter which was added in CrPC of plea bargaining, which is a new concept which is borrowed from the Western cultures, where the prosecution and defense enter into an arrangement where if the accused pleads guilty, he may be granted a lesser punishment. Whereas in not guilty, he clearly denies of any guilt of commission of the offense. Now, If he refuses to plead or does not plead or claims to be tried or is not convicted on his plea of guilty, the presiding officer shall fix a date for examination of the witnesses. Now, as I was saying, the charge is framed, the plea is recorded, the court will now actually commence or start with the trial. Now, framing of charge in different types of triable matters, the table which we saw earlier, have relevant specific provisions. 228 is for sessions triable matters, 240 is for warrant triable matters before magistrates, 246 is for warrant triable matters or otherwise on police report, SW cases, which is also before the magistrate. Now, important point to note here is, in case of summons and summary trial, specifically no formal charge is framed. A notice is put to the accused explaining the substance of the accusation, that is under 251 CrPC. This is because the punishment maximum prescribed for summons and summary trial is up to 2 years. The gravity of the offense also plays a role when it comes to the type of trial, which we saw earlier in the table. And lastly, what I said, trial will commence upon framing of the charge. Very important point to note as a defense attorney is always to think of the provision of discharge. Now, discharge is basically a remedy which is available to an accused person who has been maliciously charged. If the allegations which are made against the accused person is false, this code CrPC provides that the accused can file a discharge application. If the evidence given before the court is not sufficient to satisfy the ingredients for the offense, and in the absence of any prima facie case made out against him, he is entitled to be discharged. So this stage of discharge is always before framing of the charge. So before the charges are framed by the court, the accused has a right to file a discharge application and say that upon the material which is provided by prosecution, there is nothing against me, the case is not made out, it will be fruitless to conduct a trial in this case, I may therefore be discharged from the case. Basically is to avoid the trial so that the charges are not framed. There are lacunas in the prosecution case which relying on which there can be no guilt established beyond reasonable doubt against the accused. Therefore, this provision of discharge is given under the CrPC. CrPC prescribes discharge in three types of trial. Two types of trial, sessions trial and warrant trial, both on police report as well as on otherwise on police report, that is private complaint. But there is no provision for discharge in summons or summary trial because the gravity of the offense in that case is very less. If the accused person is not discharged, then the court shall proceed to frame the charge against him and commence with the trial. The court at this stage only looks upon the prosecution evidence. The court doesn't enter into the controversy and takes the accused documents on record and tries to make out a case. You have to show that there is a loophole in the prosecution case. In one place they have said this, in the other place it is this. There is no logical consequence. There is nothing by which I can be further, guilt can be established against me. Therefore, I may be discharged. Now, this flowchart which I have prepared is the key part of the entire presentation today. Charges are framed, the plea is recorded, the accused pleads not guilty, moves for a trial. Trial commences. Trial commences, the first step is examination of prosecution witness. Now, examination of witnesses happens in three stages. First is examination in chief, then there is cross-examination, and there is re-examination if required. Examination in chief of prosecution witnesses is done by the public prosecutor for the state, because the offenses in case of an FIR is an offense against the state. There is no private prosecution in that case. So it is done by the public prosecutor when it is the case instituted on police report. and the cross examination of that witness is done by the advocate for the accused. As a lot of people might have seen in courts, cross questioning happens in the court, witness is put into the witness box, the defense counsel asks him queries, the queries he answers, and then he makes out a case that this is a false story concocted, and therefore my client will be released. Therefore this all has to be put in the evidence of the court. This is a subject, this entire is the subject matter of Indian Evidence Act. I'm just giving a brief overview in this slide. So prosecution, witnesses, examination in chief, cross examination. Re-examination is only in very specific scenarios. If it is necessary, it is done by the public prosecutor of the prosecution witnesses. Now, once the prosecution has made out its case, the court calls upon the accused person to enter into the box and records his or her statement upon putting him questions from the prosecution witnesses evidence. Okay, then there is examination in chief and cross of defense witnesses. The examination in chief of defense witnesses is done by the advocate for the accused, because it's the other way around when it comes to prosecution witnesses. Here the witness is being called by the defense, that is the accused. So examination in chief is done by the advocate for the accused, cross examination is done by public prosecutor, and re-examination, if it is required, done by the advocate for the accused. This is regarding defense witness. This is, if any, this is not mandatory as such. There is a procedure given. If the accused wishes to call upon his witness, then he may do so. In as an attorney, speaking practically, in very rare circumstances you put any defense witnesses into the box, because you have to create a loophole in the prosecution story, which you can do by cross-examining the prosecution witnesses. When it comes to defense witnesses, if there is, it's a double-edged sword. If it goes the other way around, your accused may go into, maybe convicted in that sense. Now, evidence closes when defense witnesses, if any, are examined, cross-examined, re-examined. Then the matter proceeds for final arguments, which is done by the public prosecutor for the prosecution in FIR matters, and advocate for the defense, basically the accused. Then, after hearing both sides, the court passes the judgment of acquittal or conviction. If he is acquitted, then he is released. If convicted, then he is committed to custody. When it is conviction, then there is a separate sentencing hearing where the court decides what punishment should be granted in this specific case. The accused and his advocate is given a chance to make out a case for a lesser punishment than what is prescribed in law. If the court is satisfied, it may not impose the maximum, but seeing the overall circumstances, the court can impose maximum punishment also for the offense which is prescribed. Now, this after this flow chart, one important point which I want to discuss. Now, this trial part is done. I am not discussing more on post trial because it is a separate session by itself. There is an important provision given under the CrPC for inherent powers of the High Court, 482 CrPC, which is used for quashing of FIR and the proceedings. Okay, the High Court has the powers to ensure justice is served. If there is a wrongful implication made by simply lodging an FIR, if prima facie sees that it's a false case, the trial court cannot by itself close down the matter. The accused therefore approaches the High Court saying, see, the FIR is maliciously filed. There is no prosecution evidence which will support their case. Ultimately, I will be acquitted. This is a false case. This is out of vengeance. They are trying to take advantage of filing an FIR and launching criminal prosecution against me. You are requested to kindly quash the case, quash the FIR and the case pending before the trial court. So basically, 482 is inherent power. It does not expressly provide for quashing of FIR and the proceedings, but as a remedy, as a lender of last resort, the accused approached the High Court for quashing purposes. The By quashing an FIR, the High Court upholds the principle of fairness, protecting the rights of falsely accused persons, and preserving the integrity of the legal system. Tomorrow, the court or any citizen should not be able to question how this case and was tried, or why was this case not quashed in that sense. So therefore, the High Court, under the garb of inherent power, has the ultimate power to quash any FIR and the proceedings. There are three circumstances for exercising inherent jurisdiction: is to give effect to any order under the code CrPC, to prevent abuse of the process of court. As I was saying, that just by lodging an FIR and you are starting the criminal prosecution mechanically without application of mind, and to secure the ends of justice. So 482 power which the High Court has, is the inherent power is discretionary in nature. It is not that every case which goes to the High Court under 482 is bound to quash. The High Court has to apply its mind. The threshold is much higher in that case. The High Court has to examine the overall scenario, has to see a bigger picture, whether it is fruitful to continue with the trial of this case, or whether it is better to dispose of this case entirely by quashing the FIR and the proceedings. So the High Court may refuse to exercise the discretion if the party has not approached with the clean hands. When it comes to quashing, this is a very important judgment of State of Haryana versus Bhajan Lal. This is given by the Apex Court, where certain guidelines were given on which cases can be quashed and what are the specific ground guidelines on which basis the FIR will be quashed. So I'm not going into detail on this because we have already crossed 10 o'clock, and I understand a lot of people are thinking that it's going beyond the limit. I'll share this PPT, this judgment. You can read it online also, but very important judgment in when it comes to inherent powers. Now, just as a recap, we'll just look into the entire discussion which we have done about the trial in a flowchart from another book. I'll just reshare my screen by opening that material. Give me a moment. Is this visible? This is a booklet which is prepared by the Jharkhand Judicial Academy, Handbook of Criminal Trial 2020. There is a flowchart of the criminal proceedings which is given: institution of a criminal case, either on FIR, on police report, or otherwise. FIR, then there investigation, then there is a charge sheet, or there is a final report of a summary nature or closure report they call it. The complainant or the original informant has a right to protest this charge sheet. When it is there, the court takes cognizance and issues process. The court also has a power to disregard the charge sheet. If the accused fails to appear and is declared absconder, then the court in his absence may record evidence. If the accused appears and charge is framed, and before the charge is framed, if he is discharged, then the case closes. If the charge is framed and if he pleads guilty, he is convicted because he is pleading guilty. If he doesn't plead guilty, then the trial commences. Then what we saw: evidence of prosecution, 313 statement of accused person, defense evidence, arguments and judgment, acquittal or conviction. The similar procedure to a larger extent applies in case of a complaint, private complaint, towards the end. So when we saw a private complaint, it can be of two types: 200 private criminal complaint by the aggrieved person as a private prosecution, or when you write a complaint to the magistrate stating that the police officers have failed to register an FIR, there's a cognizable offense. This 200 is only in case of non-cognizable offenses. Now, when the court entertains this, and a cognizance is taken, the accused appears, it's a summons trial, the same procedure is followed. Warrant trial, if he is not discharged, the charge is framed. Before the charge is framed in private warrant triable matter, there's a stage of before charge evidence, or we call this evidence before charge (EBC), where the complainant enters into the box, gives his relevant evidence, says that there is a this is the case which is being made out, hence charge should be framed against the accused. The accused person has a right to even cross examine the complainant at this stage. The accused person can again apply for discharge in case of a private warrant triable matter, SW cases. If the court is rejecting his discharge application, proceeds for framing of charge, then the similar procedure, prosecution evidence after charge, statement under 313 of the um, accused, which is same in all types of matters. Then there's defense evidence. Then there are arguments and the judgment, either acquittal or conviction. With this, I conclude the long awaited 2 hour session. I hope I've done justice and tried to explain. Sorry, I tend to become a little technical, throw some sections here and there and judgments here and there. But I hope my friends were able to understand and get a broad overview of the criminal justice system in India. If there are any queries, I will address it. If you have put it in the chat box, I'll close my presentation and see. I hope the session was helpful. Do share your valuable feedback. If anybody wants to connect with me, this is the WhatsApp numbers which I have. One of which is already on the group. This is my email ID, and I've been active on LinkedIn. If anybody wishes to connect with me, I would be happy to connect on that forum. Thank you. Pallavi, you may take over.
Yeah, Kunal, is it audible?
Yes, sir. Sorry, I can't see who's
Yeah,
speaking.
yeah,
Hello.
myself is Rathod.
Hanji, ji
Yeah,
sir, ji sir.
myself Rathod.
Yes, sir.
Yeah, so really it's a great effort you have put in, and congratulations.
Thank
And
you.
one thing, uh,
Sure.
my observations, I have some doubts. You
Uh-huh.
mentioned that Schedule 2 of the CrPC,
Yes.
whether it is applicable for the special courts and special acts.
Yes, sir. So Schedule 1 speaks about IPC related offenses.
Yes.
Schedule 2 is for other special act, unless the special act itself provides for the type of trial, the cognizable bailability. If it is not prescribed, then you see the Schedule 2.
Yeah, that is okay. But nowadays we are seeing that even special courts for
Hmm.
for the all MLAs, MPs, and all.
Hmm.
So that's why whether it is applicable to that also. That's why I want to know that.
Yes, sir. That is what I'm saying. If the special statute expressly provides for these the schedule only speaks about what type of trial, which court will it the trial be before, either magistrates court or sessions court, whether it is bailable, non-bailable, and whether it is cognizable or non-cognizable. Only these three types on the basis of punishment describes. So these three, if the act is silent, the special act is silent. For example, if it's a Prevention of Corruption Act and the Prevention of Corruption Act doesn't say anything, then you refer to Schedule 2 of the CrPC to identify which court will take trial of this matter, which whether this offense is cognizable, not cognizable, whether it is bailable or not bailable. It is only for that purpose.
Yeah, that's okay. Then one more my observation is you explained that plea bargaining.
Yes, sir.
So whether that plea bargain is equivalent to parallelly to the section 89 of the CPC?
No, no, 89 CPC is for settlement. That if you are seeing, then it somewhat sees to compounding. But though they are on two different footings, the ideology is to settle out the matter. So 320 CRPC and for 89 of CPC for are to a certain extent the ideology is similar about settlement of disputes. Of course, 89 CPC says by any other mode outside the court, this 320 uses that provision, but only for the purpose of settling the case.
Okay.
Okay.
Wonderful, wonderful. Thank you.
Okay. Anyone else? Sorry, I've not seen the chat. Pallavi, can you help me out with that? If there are any queries.
Yes, I'll just quickly check. There are no questions as such because I dropped out in between because of another
Okay.
call and I joined midway. So after that, after I joined in, I can't see any questions. If there are any
1 minute.
questions,
I'll just open the chat in my screen. Sanjay ji has asked about CRPC and IPC and Evidence Act. I think I've covered this in the second or the third slide about the procedural law and the substantive law. I hope that is answered. If you still have a query, you may ask. Then, is there a statute of limitations in criminal law? With respect to taking of cognizance, there is. Uh, so the magistrate, when the case is uh, put before it, when it applies its mind, there is a provision under CRPC 468 where for different types of punishment, there is a barring of taking of cognizance. So there is somewhat application of limitation law in criminal side, especially 468, and when it comes to appeals and revision, there is the direct application of the Limitation Act. One minute, whether CRPC and Money Laundering Act goes parallelly or are they completely dealt separately? No, sir. See, Money Laundering Act is a substantive law which specifically gives out the section 3, if I'm not wrong, of the PMLA. Pallavi, sorry, your mic is disturbing.
so sorry. I'll
No problem. So money laundering, to the best of what I can recall, is section 3 prescribes the offense which are given under the scheduled offense. There the scheduled offense lists out multiple offenses which are there. CRPC on the other hand is the procedural aspect which deals with the broad overview of how the cases are to be tried. PMLA, if it doesn't have any overriding provision, then for procedural aspects, CRPC will be used. Difference between lockup and jail. So lockup, police custody is inside the police station. They make up those cells. They put the bars. You might have seen in a lot of television shows where any person is called before the police station. They take him and put him inside the lockup, which is there inside the police station itself. There, the police have the entire power to interrogate the accused person, whereas in judicial custody he is under the care of the magistrate. It is also sometimes called as MCR, magistrate custody remand. So in that sense, there is a difference between police custody and judicial custody. I hope that is clarified, Jatin. Oh, what says, sir, can accused defend his own case or an advocate is absolute? Uh, in Let me tell you, the accused can defend himself on his own. Any person in India has the power of defending himself or herself as a party in person, but in 90% scenarios, it is better to engage an advocate, because you may not be able to understand the procedural nitty-gritties, to understand and devise the litigation strategies which are relevant to win the case. The advocate puts in his expertise, his applies his or her mind, and then analyzes it, puts the best representation before the court. So I would always suggest, also as a defense attorney, I would always suggest to go with an advocate. May it be civil case, may it be criminal case, or whatever case it may be. I don't think there are any other questions, or if there are any, anybody wishes to speak or ask anything, then please go ahead. Ha, Vipul, please. Hello, Vipul. Vipul, you're not audible. Are there any questions, or have I bored everybody out in this 2 hours, more than 2 hours session? Pallavi, is there anything?
Hello, Kunal, you were very good. So most of the questions are answered. That's it.
Sorry. I couldn't hear it clearly. Can you please repeat?
I said the presentation was really very good. So most of us don't have any questions.
Thank you so much. Yes, I couldn't hear Vipul. I think he's dropped off. I think he'll probably rejoin and ask his query. Yes, Rishi, please.
Kunal, this session was truly awesome, I can tell you.
Thank you.
Most of the doubts what we have as a non-legal background person was clear, but sometime during the other sessions we may trouble also. But it's
Sure,
amazing, I can tell you.
sure.
You can
Thank you.
be a great professor, better
I
than
was
some of our
I was
also.
actually doing this session as a test run, because a lot of people, I have been boring my colleagues, my friends, my juniors with a lot of these informative sessions. I thought I could give it a hand over here and probably spread the knowledge. Thank you for the compliment.
So this can be your startup for the plan B, right? On a lighter note.
Of course,
Right,
now
right.
that I am
Thanks
qualified, I
once
can
again.
of course act as a visiting faculty in a law college. Thank you.
Okay, thanks.
Kunal, can we expect more sessions on this with case studies and all?
Uh, I can try, but I can't give a commitment immediately. If possible, I'll try to touch some other aspects of criminal law. I
Yeah.
was hoping, if in the forthcoming Diwali vacations or 1 or 2 days around Dasera or something, if I am able to make some PPT on this, because I have a idea in mind for the next topic, which is about the check dishonor cases, which is very wide, popular criminal matter sought after by a lot of people. So I was thinking if I can give a broad overview about check dishonor offense under 138 Negotiable Instruments Act. But I
It would
can't.
be,
But I won't commit to it at the moment. I'll
I
see
can
the.
understand. I
Uh-huh.
can understand. What I was thinking is like, we can, we as listeners, we can go through the PPT, what is going to share, and
Uh,
already a PDF which you have said.
uh,
And meanwhile, we'll be able to make some opinion. And the moment case study will jump into, we can have a good kind of discussion, and
sure,
that will be really informative. And
sure.
you can take your time. I mean, like as you would feel like.
Actually, to be very frank and honest with you, here I have tried to use as minimal judgments, as minimal of provisions, because I understand a lot of my friends over here are from non-law background, would find it a little difficult to understand the provisions. Therefore, I know very specific places where I wanted to use the provisions or the judgments. I've put them across in the PPT. But if there are other judgments also, I can pass it on. Or if you have any individual query, I will be happy to help. If everybody is willing for another session, which would be more in detail, where you want to discuss more on judgments and sections and all, I would be happy to do that. Sure.
So I must say you sparked the our interest in law.
Sorry, I didn't catch you. Can you
I
repeat
must
it
say
again?
you sparked our interest in law at this time.
I
Thanks. Thank
thank
you
you
very
for
much.
that.
Kunal, if you plan to take a session with more case laws, then I would request you to share the PPT or reading material earlier.
Okay. Okay, no problem. If it comes on that aspect, then I'll surely put up the PPT in advance or put some reading material so that everybody is aware about the topic, and then we can have a fruitful discussion in that sense. Rishi, your hand is still up. You want to add something or any query?
No, I think I just forget to
No problem. No
lower
problem.
my hand.
Kunal, I think Asha ma'am was saying something, but she got cut in between, probably due to a network issue or something.
Yes, please, madam. Please. Yeah, I think she's there, but she's not responding or unable to hear us out.
She's speaking. I think there is some network error from your end, or maybe
I
some.
no, I can't hear her. Sorry.
She was. I can hear you, Asha ma'am. Like, but I don't think Kunal is
Sorry,
here.
sorry, I'm unable to hear you, ma'am. Can you reconnect or use some other device? Sorry, I'm unable to hear you. Or you can just type it out if that is possible.
Kunal, can you hear me clearly?
Yeah, I can hear you, Pallavi, but I think
Okay, fine.
I can't hear Asha, ma'am. Even
Right.
Jagrati is saying even I can't hear.
I think
Jatin is
she
also
was
saying.
just saying some words of appreciation
Oh,
because
thank you, thank you.
making something this elaborate and so like giving things in so much detail in a 2 hour span is something very commendable. And even I didn't know what to expect from it, but I'm really happy this session has turned out to be so enriching. And I
Thank
must
you.
once again, on behalf of everyone, as um, as my class monitor duties specify me to, I must thank you formally for taking this session for us, for doing for taking all efforts for making this session like so enriching for all of us.
Thank you for giving me the opportunity, and thank you for handling the hosting the meeting, and also a shout out to our backbenchers group, people who have joined and supported. I hope I have done justice to everybody. I am assuming this has not gone as a Yorker or a bouncer above everybody's head.
No, I think it's because when we speak about criminal law, we come across it in some form or the other, right? Either in we read it in news, otherwise we watch it in movies or something. So there's always words which are thrown around, like what is prosecution or what is bail and all those things. We still wonder about these kind of things. So it is easier to relate to in that manner, probably because we hear about it a lot. Crime, crime and criminal laws and crime shows, and like we're all into it. So I think this was a very apt session, or something very apt topic that we have taken up, and luckily we have you, our in-house expert on this, so we
Thank
could
you.
bank on you for taking this session.
Thank you.